So I've talked about what a patent attorney is before. The United States Patent and Trademark Office, in its wisdom, has decided to extend the patent bar to a new type of practitioner that's limited to design patent applications only. This new rule is going to create what are called design patent attorneys and design patent agents. This rule is going into effect on January 2nd of 2024. I'm afraid it's going to create a lot of confusion for you as to what attorneys can do what type of work. And so I want to get ahead of that and clear that up now. And we're going to talk about that in this video. So I've created a table here to discuss the new design patent bar. Now, the design patent bar is going to allow this new type of practitioner to come into force as of 2024. And it's going to take a little bit of time. They're going to have to take the same patent bar exam that all other patent attorneys have to take, but their qualifications to sit for the exam are going to be different. They're going to be less stringent than they are for a regular patent attorney. Now, they're still going to have to meet some criteria. So design patent practitioners are still going to have a bachelor's, master's, or doctorate of philosophy degree in any of the following areas from an accredited college or university: industrial design, product design, architecture, applied arts, graphic design, fine studio arts, or art teacher education, or degree equivalent to one of those listed degrees. So they're still going to have some academic credentials in order to sit for the exam. But there's going to be very important differences between what a design practitioner can do and a regular patent practitioner can do. And so this table is designed to help you figure out what those differences are. Now, at the top, I've listed out some of the capabilities or some of the practice areas that attorneys and agents can engage in. So I left off plant patents, but for purposes of this table, think of plant patents as the same as utility. In fact, let me add that in there. What applies to utility patent applications also applies to plant patent applications. So we've got utility or plant patent application preparation and prosecution, design patent application preparation and prosecution, and then other things that attorneys do like licensing contracts, maybe trademark applications in the United States Patent and Trademark Office, and litigation. Now, not all attorneys are going to want to do all this type of work. What I'm talking about here is what practitioners are allowed to do under their license and under the ethical rules that go with that license. So we're going to have 4 different types of practitioners now in the USPTO. A regular patent attorney, which I happen to be, a patent agent, a design patent attorney, and a design patent agent. So let's first look at the patent attorney. So the patent attorney, can the patent attorney prepare and prosecute utility plant patent applications? Yes. Can the regular patent attorney prepare and prosecute design patent applications? Yes. Can the patent attorney do licensing contracts? Yes. Trademark applications? Yes. Litigation? Yes. So the patent attorney can basically do all the functions that a licensed attorney can do, and from the standpoint of patents, can do work on utility or design patent applications. Now, the patent agent is not an attorney, but they're licensed to practice before the USPTO. So a patent agent can work on utility and plant patent applications, preparation and prosecution. They can work on design patent preparation and prosecution. They cannot do contract work. They're not an attorney. They can't file trademark applications because they're not an attorney. And they can't engage in litigation because they're not an attorney. So that's been the nature of patent practitioners going way back to the very inception of patent practitioners, except there actually was a time, when if you sat for the patent bar, and this was many, many years ago, if you sat for the patent bar and passed, you were automatically considered an attorney. So there was a time where there was no patent agent and you just were a patent attorney. But those days are gone, and now there's a differentiation between patent attorney and patent agent. Now, the new design patent attorney, again, This is a person that's a licensed attorney, so they'll be able to do anything that a licensed attorney could do. So I'll start at the other end of the table. They can engage in litigation. They can file trademark applications. They can produce licensing contracts, draft and negotiate them. Now, they can prepare and file and prosecute design patent applications before the USPTO. But they cannot prepare and file utility patent applications. That's left for the regular patent attorneys and agents. So a design patent attorney will not be able to do utility patent application or plant patent application work. The design patent agent now is even more limited. The only thing that they'll be able to do is prepare a design patent application and prosecute it through the allowance. They can't do anything with utility patent applications. They can't do anything that would be considered attorney legal work because they're not a licensed attorney. So hopefully this isn't going to create a lot of confusion in the inventor community, and the inventors will know the difference between these types of practitioners. The issue that might come into play is that if you have a situation where your invention could be subject matter for a utility and a design patent application, and you go to a design patent practitioner, that design patent practitioner won't be able to help you with the utility aspect. And if you go to a regular patent practitioner, they can help you with the design aspect of your invention and with the utility aspect of your invention. So you have to understand that when you're seeking out patent practitioners now with the new coming design patent bar, because there are going to be practitioners that can work on design patent applications but not utility. Hopefully this table helps to clarify that, and I'm hoping there isn't going to be a lot of confusion in the community, but if anybody is confused, look at this table to kind of get an idea of who can do what, and hopefully this table will be helpful. So if you did find this video to be helpful, please like and subscribe. That helps a lot. I noticed a lot of my viewers aren't subscribed. Please subscribe. I've got a lot of good stuff planned coming up. If you know anybody else that you think might benefit from this information, please share it with them. That helps me out also, and I really appreciate it. So that's all I have for today. Remember, stay inventive.